My Lord, I don't need to do introductions. I think the Lord has a list before you. The purpose of this hearing, as you will have seen from Lord Justice Green's order, is for Mastercard and Visa to have the opportunity to persuade the court that there are issues of law which arise, and Mr. Kennelly and I will divide the submissions between us on the various grounds. We each adopt each other's grounds. In our submission, there are a number of fundamental legal errors in the tribunal's judgment, each of which justifies permission to appeal being granted. And we will go through the key errors, but may I, just by way of introduction, without developing them, identify a few notable examples. First of all, the tribunal failed in several instances to refer to, or indeed to follow, binding authority, including the judgment of this court in these very proceedings in the June case, and for your note, that is in the authorities bundle at tab 10.
Yeah, I should just say we've had a fair chance to read in advance, and we have on board, I think, the broader points you're probably going to go through now, so you can take these quite quickly.
I will do.
And it would be helpful if you focus when you come to the actual grounds on what the respondent has so far said as to why you shouldn't have permission.
Indeed, I'll do that. Just to complete that point, as you will have seen, therefore, the tribunal contradicted the judgment of the Court of Appeal on the legal test for the appropriate counterfactual, and did so without referring to the Court of Appeal's conclusions and reasoning on those issues. Secondly, the tribunal in several instances determined issues that were not properly before it, or departed from the cases advanced by the parties without offering the opportunity to the parties to comment or argue on those issues or putting the case to their witnesses. And the most remarkable examples of that type of approach was the chair's own analysis of the relevant market for the purposes of Article 101, despite a wing member of the tribunal stating it was impermissible for him to do so, because neither part of the parties nor the experts had approached market definition in that way. In answer to my Lord Zacaroli, Lord Justice Zacaroli's point, the claimant's only response on that point is to say, well, it doesn't matter because the other member of the tribunal approached it differently. That's not right, as I'll come on to show you, because Mr. Tidswell's judgment was actually infected by reliance on the chair's error in this regard. Another example is the tribunal analysed the restriction of competition in a way that was not argued by either party and which was in direct contradiction of an earlier judgment in these proceedings that had addressed and rejected that analysis. That's the Westover case, which I will develop in a moment. And then in another instance, the tribunal declared that a category of myths that was not even in issue in the trial, the pre-IFR myths, amounted to an infringement by object, contradicting an earlier tribunal judgment on precisely that question in a case where, unlike in Trial 1, those myths were an issue and were the subject of evidence and submissions. With that introduction, my Lord, may I outline the structure of the appellant's submissions, which will be made by me and Mr. Kennelly. I will go first on ground 1, focusing on ground 1B, and identify that error. Mr.
Just so that let's have the English description of that. That's
indeed, my Lord. So it's in the core bundle, and it's Mastercard's grounds of appeal at tab B, page 18, and it's one subparagraph 2, in fact, in this, which is the default interchange fee rule.
It looks as though we might have slightly different tabbing from you, but you give the page number.
Oh, I apologise.
I don't think I've got it.
It's tab 1B in my bundle, which
Okay, I
is
haven't
page
got that.
18.
But I've got page 18.
Thank you.
Is there a transcript being made of today?
Yes, there is.
Right,
Thank you. Mr. Kennelly is going to follow on what Mr. Justice Marcus Smith called the stickiness prior record points, which you'll see in our grounds at 1.3, and 1.1 will be picked up in the course of submissions later. We will then move to ground 2, and Mr. Kennelly will address the legal and common points applicable to the UIFM and through the bilaterals counterfactual, and he will then develop his submissions on the UIFM counterfactual, and I will follow briefly on the bilaterals counterfactual. And then Mr. Kennelly will address you on object infringement, which is Mastercard's ground 3, and for your notes it is Visa's ground 4, which you will find at page, their grounds are at 34, and you will find that at pages 34 and 35. And then finally, as regards Mastercard's ground 4 and Visa's ground 3, each of us takes different points, and we will rely on our written submissions in that regard, because we don't think we'll have time to develop them further.
Would it be fair to say that the kernel of this case on by effects restriction is the identification of the appropriate counterfactual?
Indeed.
Because once you've done that, the question of whether there is a restriction or not rather answers itself.
That's right.
And so, although ground 1 is very interesting,
I understand.
what matters is how that, if it does, runs through into the errors in ground 2.
And that's one of the reasons why market definition will be picked up later on, for that very reason.
Yeah.
I am going to start just with the, and I think indeed Mr. Kennelly's planning on dealing with stickiness in the course of submissions on ground 2. The only reason I'm highlighting the default interchange fee rule is because it is a clear error of law, and it does infect, we say, the approach to the correct counterfactual and other matters. In terms of timing, my lord, Mastercard and Visa have up till 1 o'clock, subject to the court's agreement. The respondents will have 90 minutes after lunch, and then there'll be time for reply, of course subject to the court's preference. So may I turn then to ground 1, and you've seen that there are 3 overarching errors of approach that apply, we say, to the conclusions reached by the tribunal on the ultimate issues in trial 1, because they constitute the framework against which all subsequent analysis takes place. And if I can focus on what is ground 1 little 2, this is addressed in our skeleton argument at paragraphs 31 to 40, and as I've just said, concerns the tribunal's finding that the default interchange fee rule was itself the putative restriction of competition. And the reference to the judgment paragraph is 237, but I'll show you other passages. Now, as my lord will appreciate, the default rule is the scheme rule that permits Mastercard to set default MIFs. So it is in effect an enabling rule. And the tribunal were clearly told this in a note that they requested, which Mastercard produced during the course of the hearing, the note on the bilaterals counterfactual, which cited Rule 8.3 of the scheme rules. The claimants do not dispute this. The enabling rule language was used by both sides in the Westover case, which I will come to shortly. And at trial, critically, the claimants did not argue that the default rule itself restricted competition. At trial, all parties advanced their respective cases by reference to each of the specific categories of MIF at issue, and all adduced evidence addressing the specific MIFs separately. This is an example of where the tribunal ignored the parties' arguments and evidence on the specific MIFs and invented what they described as a MIF-indifferent analysis that focused on the default rule itself, and an example of that is at 259 subparagraph 3 of the judgment, and again I'll show you that in a moment. The tribunal, my lord, erred in adopting that approach for 3 reasons, each of which we suggest involves a point of law, and each of which on its own would overturn the judgment on this point. The first reason is that the tribunal clearly proceeded on a basis that was not canvassed before them, using the language of Lady Justice Falk in Phones for You, and the tribunal thereby exceeded their function That point is addressed at paragraphs 35 to 36 of our skeleton and is a point of law because it is impermissible as a matter of law for a judge to decide a key issue on a basis that was not canvassed at trial without giving the parties a proper opportunity to address that basis in submissions and, if necessary, in evidence. And we refer at paragraph 20 of our skeleton to Lady Justice Fawkes' summary of the legal principles infos for you. And just standing back, my lord, it was manifestly unfair to decide the core restriction issues on a basis not advanced by any party, that was not the subject of factual or expert evidence, and was not raised with the parties for comment. And the tribunal's finding that the default rule itself restricts competition is not only wrong and contrary to binding authority, it's a far-reaching finding that needs to be corrected because it affects all interchange fees, no matter their context, application and time period. The second point, my lord, is that the default...
Can I just ask you a question, which is just a rather mundane one? The tribunal refers at various stages to a list of issues, but doesn't actually annex it to the judgment. Is that something that we've got?
Yes, it is, and I'll find you the reference to it, my lord. It was, I was going to come to it actually in a moment.
Well, I don't want to take you out of your course.
It's in the supplemental bundle, as Mr. Kennedy is helpfully pointing out, in tab 8, page 54, and it is illuminating, and I'll come to it in a moment, my lord. The second point is that the default rule analysis was not open to the tribunal, and we address that in paragraphs 38 to 39 of our skeleton. Some time before trial 1, a differently constituted panel of the tribunal in these proceedings determined the default rule issue in favour of the schemes. That is the Westover decision cited at paragraph 38 of our skeleton. And the tribunal in Westover held that the default rule is not a restriction of competition, and that finding was binding on the parties. And if I may briefly show you the judgment in Westover, which is in the authorities bundle at tab 7.
I'm sorry to rise, my lord. Could I just clarify one thing? The Westover claimants settled out their case in November 2023, so they weren't part of this proceeding.
Well, both parties proceeded, as I understood it, on the basis that Westover was binding and didn't actually challenge. Nobody at trial 1 challenged.
So Westover wasn't cited.
Westover was not cited, I agree, because it wasn't, the issue wasn't live, and certainly my learned friend didn't argue the case on the basis that Westover was wrongly decided. As my understanding goes, he regarded the finding in Westover as correct, and his case was put on that basis, which is why he argued that each MIF category had to be looked at separately. If we go, please, to page 612, that's the start of the judgment, and then the summary, rather, and then the judgment is at 615. And paragraph 2 provides the context for the tribunal's consideration of the essential content of the restriction of competition at issue. And there is a very clear summary of the background to the proceedings at paragraphs 4 to 16, if you would say summary.
Is that the summary we'll have seen many times?
It is, yes. And then, my lord, turning ahead...
Sorry to ask rather another mundane question, just arising out of that exchange. Was this made in these proceedings?
It was.
So, I mean, is there a number for the proceedings or anything as simple as that?
My lord, I will check that and
but anyway, you say
come back to you. But it was in these proceedings, and it predated the June decision. So it was Westover, then June, then trial 1. Right. And if one goes forward to paragraph 27 at page 623, what you will see is, and just pausing there, if I can just interject with the point that I should make clear, our position is this was binding on the tribunal, but even if I'm wrong about that, what we say is the reasoning is correct. It was plainly a decision that should have been in the tribunal's mind, and it should have been at least, if it was going to be disregarded unilaterally by the tribunal, it should have been engaged with. It was also never suggested by the claimants that it was anything other than correct, and their case was put on the basis that it was correct, otherwise they would have mounted the argument in Westover that was rejected. And if I can just show you what the argument was and where it was rejected. At paragraph 27, the claimant's argument at that stage is identified, and they contended that the default rule itself is the restriction, with the particular MIFs actually set by Mastercard being relevant only to the quantum of damage or exemption. Now, that was not the argument run by my learned friend below, but this was what was argued here. Then at page 624, paragraph 34, you see the claimants relied on the Sainsbury's decisions of the Court of Appeal and Supreme Court judgment to argue that the restriction of competition is the default MIF settlement rule. And that argument runs to paragraph 42 on page 627. And just to highlight perhaps paragraph 40 in that run. And if one then, when your lordship's ready, goes to paragraph 43, you see Mastercard's argument that it's the default MIF settlement rule does not in itself impose any MIF, it's purely an enabling rule. There is then a point about whether zero MIFs are realistic, but we can pick up the main thread in the third sentence of paragraph 45, beginning, however, we do not think we need to reach a concluded view on this, that's the realism of it. Even if setting positive MIFs had been the common expectation, that does not mean the actual setting of a positive MIF was not an essential element in the restriction of competition. And could you please read on from there and also paragraph 46, my lord? Now, there are three key points to be taken from...
Can I just grasp the essentials of this? So the rule that's being referred, the default rule that's being referred to there is what, in very plain terms?
8.3, which permits Mastercard and its scheme rules to set a MIF. It's an enabling rule.
I see. Okay, and so the MIF that's set is one that's set by Mastercard. I see.
And do we need to show you, my lord, it wasn't included, you may have received correspondence about this, the note that was handed up that contained the rules wasn't in the bundle. And we have copies if you wish to have it.
We both read that, I think.
Right, thank you.
And so the rule is, the existing rule is 8.3,
I think, my lord. paragraph 9 of the note. A transaction settled between customers gives rise to the payment of the appropriate interchange fee or service fee as applicable.
And somewhere else, Mastercard has identified what the applicable fee is, but it's in default of agreement, isn't it?
Yes, exactly.
Yes.
That's the default rule, exactly.
Yeah.
And so the first point, my lord, follows from that, which is the default rule is merely an enabling rule. It does nothing more than establish the underlying contractual right for Mastercard to set default MIFs. So it could only, at best, set the scene for a restriction to arise. It can't be the restriction itself. So to illustrate that, if Mastercard set a default MIF of 0 under the default rule, there would be no restriction of competition. And hence the discussion in Westover of the point.
In fact, we're dealing with a scenario where Mastercard did set a default rate.
That's right.
So your point is that the tribunal somehow missed that fact in defining what was the restriction on competition.
Well, yes, and also there are different MIFs for different rates for different types of MIFs. So, and that's why the parties argued their case on the basis of the different MIFs and different counterfactuals for the different MIFs. Now, the claimants case, which I'll come on to, was, well, all of them are unlawful, and their only answer to this error of the tribunal is to say, oh, well, the outcome was the same on our case, so therefore it wasn't something that was invented by the tribunal. But we say that's just not right. The legal analysis of finding that the rule itself is the restriction of competition is wrong, but also entirely inconsistent, this was my second point, with the Supreme Court's approach in Sainsbury's, irrespective of the Westover decision. Because the Supreme Court, as your Lordship knows, identified 6 essential facts which were the basis for restriction, for the restriction finding upheld by the CJEU in the Mastercard case. And those 6 elements include, first, that the MIF sets a minimum price floor for the merchant services charges paid by the merchants. And secondly, in the absence of the restriction, those charges would be lower. And just for your note, the 6 elements are identified in paragraph 93 of the Supreme Court's judgment, Authorities 4, page 482. Now, neither of those 2 elements can be present unless there is a substantial positive default MIF imposed under the default rule. The mere existence of an enabling rule can't satisfy those 2 elements of the Supreme Court judgment. So there would have been no point in the Supreme Court formulating the test if one never needed to consider the actual MIF set, because the default rule itself is inherently unlawful. And then the third point, my lord, is that the idea that the default rule itself is a restriction of competition is incompatible with the Court of Appeal's analysis in the June decision. The focus in June on the potential for there to be different counterfactuals and different outcomes for different categories of MIFs, as Mr. Kennelly will show you, that focus would have been completely otiose if MIFs are unlawful simply because the enabling rule is a restriction of competition. So the tribunal's approach was also inconsistent with the June decision, which is binding upon it.
So I can see how you might springboard from this to your argument later on about that the tribunal should have looked at different categories of MIF differently.
That's right.
But on this pure point, it would be surprising if the tribunal had completely forgotten what the 6 facts in Sainsbury's were. And I think the respondent's point on this is that although in one place you can find a sentence which does reflect entirely your point, looking at the judgment as a whole, actually the tribunal was considering not only the default rule as described, but also the fact that positive MIFs were set.
So can I show you the passages of the judgment on which we rely? My learned from Mr. Bill, I think, relies on 2 points. One is that although you can find that statement, the outcome shows that they were considering levels of MIFs. That's his first point. And his second point, I think, is that there was an attempt to reconcile the finding by the tribunal with the Supreme Court's decision. So they didn't ignore it. So if I show you that. So the claimant's response, as I said, is at paragraph 2.2. And they say in terms, and George wants the reference to that, it's in the core bundle at tab 5, starting at page 88, and paragraph 2.2 is at page 89. And if Your Lordship just reads that. And obviously, it's not, the point is not taken here that Westover is not binding or that Westover was not right or to be applied. Now, that response is wrong for two reasons. First, the unanimous disposition in 353 of the judgment, if we can just look at that, it's at tab 8 of the core bundle, page 316. That sets out the tribunal's conclusions on the basis that we unanimously find that the default interchange rule infringes Article 101. So that couldn't be clearer, and the in particular then sets out the scope of the findings, but it is the default interchange rule that is said to infringe. And that's not an error, because when we go back to the judgment, you'll see that it is followed through in the judgment. So it doesn't say, for example, that commercial card MIFs in the UK and Ireland restricted competition in the relevant period. The chairman's judgment is equally clear. On his analysis, the restriction on competition has nothing to do with the detail of any category of MIF in its market context, but results straightforwardly from the enabling rule itself. And I will show you the paragraphs. They are 238, 254, and 259, subparagraph 5 of the judgment. And
sorry, say that again. 238.
238, 254,
Yeah.
and 259, subparagraph 5. And I'll show you those now. I just say to you that before I do, the response in 2.2 of the claimant's response does not engage with these passages of the judgment. If we could look at paragraph 238, please, which is on page 271 of the core bundle. Now, the first sentence of subparagraph 1, you see, first of all, it says pointless and analytically wrong to differentiate between default MIFs. It is pointless because, as the merchant claimants have repeatedly said, the analysis is exactly the same, whatever the default MIF. Now, that is not right. The claimant's position was that the outcome of the restriction by effect analysis was the same for all the MIFs at issue. They did not argue that it was wrong as a matter of law to analyse each MIF distinctly, nor did they contend that it was the enabling rule itself that was the restriction. And if I could now just show you the list of issues.
2381 doesn't suggest, does it, that the enabling rule is the restriction? I mean, the implication I get from 2381 is that it's only where there is a fee, a positive fee imposed. So it assumes there's a default rule, a permissive rule, and that a fee has been imposed.
It may be, but if we go down to the second line of the second sentence, and the rule that constitutes the infringement of Article 101 is the default interchange fee rule, under which multiple and varied individual default MIFs are promulgated. And if you could look as well, my lord, at 237. That first sentence. So the question isn't whether specific default myths infringe, but whether the rule infringes. Now that is exactly what was said not to be enough in the Westover case for good reason. And it doesn't seem to be in the chair's mind, at least, that you needed both elements. He regards the rule itself as the infringement, even if the implication is that there are myths set under it. And
I mean, again, it might be said, if you look at the last sentence of that paragraph, that he's only really talking about a case where there's a positive myth, in fact, imposed under the rule, because it says the point is that the merchant should not receive less than 100% of what the customer pays by reason of the imposition of the myth.
But that, my lord, ignores the Sainsbury's debate that even that a small myth might not be enough to be a restriction of competition. It has to be a substantial myth. So just the imposition of any myth isn't enough. And it also would suggest that you don't need to analyse the different categories separately, which of course is not the way in which the Supreme Court approached it, June approached it, and indeed Westover assumed it would be approached.
That's the second point, which at the moment I see as a slightly different point.
Yes.
Yeah.
But the first point is that, my lord, just in answer to your question, it seems clear to us from these passages, I'll show you further ones, that the chair certainly thought it was the rule itself and it just didn't matter what the different level was. And in answer to my Lord Justice Miles' question, it's not enough just to have even a small positive myth. You've got to have a substantial one. I was just on the point that as to what was argued, the list of issues which my Lord Justice Miles asked about in the supplementary bundle at tab 8, page 54, reflected the myth-by-myth approach adopted by both sides and did not include an issue on the enabling rule itself. And the relevant issues start at page 59 with issue 3, for your Lordship's note. And so that was the way both sides approached the case, not in this way by saying it didn't matter whether specific default myths infringed, because both sides did in fact approach it in that way. If we then go to the second subparagraph of 238, that misstates the position quite dramatically, because it was and remains Mastercard and Visa's case that there are different counterfactuals for different categories of myth. And so that is not a correct statement.
Paragraph 238.
238,
Yeah.
subparagraph 2. And that was clear from our written closings, for example, at paragraph 3. If we could then, my Lord, go to paragraph 254 on page 279. In the final sentence over the page, we see the misstatement of the claimant's case, which I've already highlighted, that the analysis is default myth indifferent, which the merchants claim is central point. That's not the way they argued the case. And what the claimant said was that conducting the myth-by-myth analysis, which they did individually, led in every case to the same outcome, but they did not invite the shortcut of treating the default rule as the restriction of competition, whatever the myth. And more fundamentally, this is the paragraph I mentioned where the tribunal tries to reconcile its view that the restriction of competition arises from the enabling rule itself with what the Supreme Court decided in Sainsbury's and the Court of Appeal decided in June. And it said it was because of the way those cases were pleaded, and itself is a function of the prior record, and that the Supreme Court's analysis was not in any way dependent on the types of default MIF that were before it. It's then said that the approach of the Supreme Court was open to challenge and contrary argument by the scheme. Well, that's just wrong. We weren't trying to challenge the Supreme Court's analysis. We, in fact, relied on it in our pleadings, expert evidence, and our submissions. And then it said that June allows the challenge to the Supreme Court, which it just simply doesn't. Nowhere did the Court of Appeal say in June that it was arguably open to Mastercard to challenge the Supreme Court's analysis. We'll come back, my lord, to precisely what the Court of Appeal decided in June. Mr. Kennelly will show you, but it isn't as presented here, so when he shows it to you, perhaps you can keep this paragraph in mind. And it's not, we don't accept the reasons outlined that the Supreme Court's analysis is to be characterised as it is here by the chair. If we could then go to 259, subparagraph 5. And in fact, Your Lordship may wish to read the whole of 259. So, in little 2, however, having heard the evidence, this judgment holds that the Supreme Court's analysis holds good in relation to all MIFs because the anti-competitive aspect of the interchange fee regime is not in relation to specific default MIFs, but in relation to the default interchange fee rule generally. This holding is consistent with the Supreme Court's decision, but represents an extension of it. So he is saying it's the rule, and he's saying that he's extending the Supreme Court's analysis. In fact, we say, for the reasons I've given, it's not consistent with it. The chair then went on to say it is significant in this regard that the Supreme Court's analysis was MIF indifferent. Then at 4, it follows it does not matter who set the MIF. The default MIF remains anti-competitive. And then 5, it also follows that the differentiation between different MIF types is a red herring. The mischief lies not in the level of the default MIF, nor in the fact that its level may be driven by reference to different factors. The mischief is the rule, irrespective of the specific default MIF in question. That was an open question the Supreme Court held to be arguable in June, but the argument has now been determined and the point is a bad one. Now, just pausing there, we say it couldn't be clearer that it's the rule. He didn't follow the analysis of the Supreme Court and in June all that put forward by the parties in the examination of the different types of MIF. We say it wasn't an open question in the Supreme Court, and it wasn't a point that was determined with proper argument from these parties, and in any case it is wrong. And the reason it's important, as well as being a very clear point of law with consequences that follow, is because it feeds in, as you will see when Mr. Kennelly addresses you, into the suggestion about there not being an appropriate counterfactual, and indeed a lack of understanding that different counterfactuals could apply to different MIFs, which was one of the reasons the counterfactuals were said not to be viable. So it does cause further error, but it's also an incredibly significant error because it undermines, we say, the Supreme Court's analysis, and it also doesn't follow prior decisions in these very proceedings. And whatever Mr. Bill wants to say about that, I can reply to. But obviously, the decisions in Westover in June were in these proceedings. They were proceedings that became the umbrella proceedings. Irrespective of the different claimants joining it, they were decisions in these proceedings. Now, just for your note, I won't take up any more time given Mr. Kennelly's due to develop his points. But none of the chairman's analysis on this is questioned or contradicted by Mr. Tidswell or Professor Waterson in their judgments. And there's no disagreement of the analysis of the default rule. My Lord, may I hand over now to Mr. Kennelly?
My Lords, Ground 2 concerns the Tribunal's failure to apply the correct legal test in relation to the counterfactual. Counterfactual, as my Lords know, is the legal tool used to determine if the agreement in question has the effect of restricting competition contrary to Article 1011 TFEU. The counterfactual, state the obvious, is the situation which arises if the challenged agreement or measure is removed. And the legal question is, if the challenged agreement is removed, does the harmful effect still occur? Because if the harmful effect still occurs, even absent the impugned agreement, that agreement is not causing those harmful effects. The Tribunal's first main legal error was to find that the counterfactual had to assume not only that the impugned agreement was removed, but the harmful effects also. And that completely misunderstood the legal function of the counterfactual. The Tribunal's second main legal error was to find that the counterfactuals advanced by the schemes were themselves necessarily collusive arrangements restricting competition. And that argument had already been rejected by the Court of Appeal in June, and was obviously wrong in any event, because in these counterfactuals, the interchange fees are not set collectively, and Article 1011 is only concerned with collective action. Subject to the Court, I will show your Lordships the correct approach to the counterfactual issue in June in the Court of Appeal, and then I'll show you where the Tribunal went wrong in the judgment. So to the Court of Appeal in June then, authorities bundle, it's in my volume 2, it's tab 10. Your volumes may be different, but it's in tab 10 of the authorities bundle. And since the Court has also done some pre-reading, I will skip straight to the relevant page 701.
Can you give me the I got it separate. Give me the paragraphs.
Paragraph 21. And before I get into the submissions that were made in June, I want to take the Court to the proper legal approach to formulating a counterfactual as a matter of law. And so in paragraph 21, I'd ask you to skip to the second sentence, which is a citation of a case from the European Court, Cap Bancaire, which was adopted by the Court of Appeal in the Sainsbury's case. And it says that to determine whether an agreement must be deemed to be prohibited due to the resulting distortions of the competitive process, it is necessary to examine the process of competition in the actual context in which it would occur in the absence of the disputed agreement. And skipping down to the indented passage, the General Court of the EU went on, the analysis of the competitive situation in the absence of the measures in question aimed to determine whether the measures restrict the competition that would have existed in their absence, This concerns in particular determining whether, in the absence of the measures in question, the competitive situation would have been different on the relevant market. That is to say, whether the restrictions on competition would or would not have occurred on this market. So as my lords can see, in the counterfactual exercise, there is a legal test and a factual question. The legal test is, if the impugned measure is removed, does the same harm to competition arise which is allegedly caused by the measure? The factual question is, if the measure were removed, what in fact would the parties be likely to do? And what would the consequences be of their action? Now, to appreciate the tribunal's error, your lordships need to see how these questions, these legal and factual questions, were answered in the Sainsbury's case, in the Court of Appeal, and in the Supreme Court of the United Kingdom, where the UK courts followed the Court of Justice in the Mastercard case. And for that, I'd ask you to go to page 706, still in June in the Court of Appeal. And you'll see how the Court of Justice of the EU formulated the counterfactual in that case. So the question was...
Which paragraph are we on?
Paragraph 36, my lord, at the top. So the question was, if the multilateral interchange fee was removed, what do the schemes issuers and acquirers do? And before my lords read this, obviously if the multilateral interchange fee is removed, the question is, would the issuers and acquirers just negotiate interchange fees bilaterally? And as you'll see, they would not. They would not have done that because of what was called the hold-up problem. And to take them slightly out of order, I'd ask you to read about that, please, first, at paragraph 37. Read, my lords, 37 to yourselves, and then I'll ask you to go to paragraph 36.
Sorry, I've got my own copy of this, but I must have got the wrong case. We're looking at Sainsbury's. What's in the?
It's in June.
I'm sorry, it's in June.
June's
Sorry.
quote. Oh, thank you.
Yeah, sorry, paragraph 37 of June, it's an indented passage that begins 2.8.
Right. Yeah.
This is addressing the factual question as to what the parties would do in the counterfactual.
So the point about this is that it's, as it were, in the interest of each individual issuer to take advantage of its specific bargaining position in relation to that transaction, because that is something that's just happening, as it were, behind the veil.
Yes, it's a function of their own individual market power.
In a particular case.
Yes, exactly. They have, because of...
So they will always be, the idea is that they'll always be incentivized to charge as much as they can.
Absolutely.
And it will just keep going up.
In their own greedy self-interest.
Yeah.
They will individually drive up the interchange fee. And if they're not constrained, it will lead to the collapse of the scheme, or at least it'll lead to a much smaller scheme. And
Just to square that circle, so that each issuer is incentivized to do that.
yes.
Is there competition between issuers for the acquirers business, for transacting with acquirers?
There is some competition, but it's weaker because the acquirers must.
Well, first they must, and secondly they pass on the cost of the merchants.
Precisely.
Yeah.
So, but the real competition that's driving up the interchange fees is the competition between the issuers. They have an incentive to get card holders and to attract card holders with points and air miles, and so they fund that with interchange revenue.
Yeah.
So the issuers competing with each other drive up the fees, and the schemes are significantly harmed as a result. And in paragraph 36, you see why, facing that outcome, the schemes, if they were told they couldn't have positive interchange fees, would set the interchange fees at 0. Paragraph 36, Lord Justice Newey says, the CJU's reasoning was essentially that what has been called a hold-up problem meant that for the Mastercard scheme to survive without a default MIF, ex-post pricing had to be prohibited, or in other words, there had to be settlement at par, which is the same as a 0 MIF. It's common ground. And Mastercard would have preferred to adopt that solution than to let its scheme collapse. So that was the counterfactual. And compared with that counterfactual, the settlement at par counterfactual, the courts found that the MIFs did cause restrictive effects in the acquiring market. And we see that at page 698. If you go back, please, page 698. Paragraph 93 of the Supreme Court's judgment is set out at the bottom of the page. My friend, Ms. Delaney, referred to this paragraph. Now, if I could just take you to it. At the very bottom of it's on paragraph 14, my lord, of the June judgment, indented paragraph 93. And here we have the legal test for a restriction of competition contrary to Article 101.1, where these facts exist, there is a breach of Article 101.1. So this sets out the legal requirements for a breach in this context. And taking them in turn, little Roman 1 first. The MIF is determined by a collective agreement between undertakings. So that is the impugned agreement, which is said to produce restrictive effects. Then we see the effects next at little 2 and little 3. The collective agreement has the effect of setting a minimum price floor for the MSC. The MSC is the merchant service charge that the acquirers charge merchants. And 3, the non-negotiable MIF component of the MSC is set by collective agreement rather than by competition. So those are the effects of the collective agreement. There's a MIF constitutes a non-negotiable chunk of the MSC, and that part of the MSC is immunised from competition between the acquirers. But to test if those effects are produced by the agreement, we need a counterfactual. And it was common ground that the counterfactual was a no default MIF with settlement at par, a prohibition on ex post pricing. We see that at little 4, and we've seen that the Court of Appeal in June, citing the Court of Justice in Luxembourg, identified why that was the counterfactual in that case, because it was the only option available to the schools in view of the hold-up problem. And then 5, we have the answer to the comparison with the counterfactual. In the counterfactual, there would ultimately be no bilaterally agreed interchange fees. And 6, in the counterfactual, the whole of the merchant service charge would be determined by competition, and the MSC would be lower. And that approach properly reflects Article 101.1, which seeks to prohibit agreements which have the object or effect of distorting competition. But both are needed, the agreement and the effect or object. But then, my lords, as you've seen, we have the interchange fees regulation. Actually, before I get on to the interchange fees regulation, for completeness, may I show you the rest of the Supreme Court judgment that we see, the relevant extracts on page 699, and just pull out 3 of those paragraphs. Paragraph 99, I'm stressing, of course, the relevance of the collective agreement. The Supreme Court said, and the facts as found, the effect of the collective agreement to set the MIF is to fix the minimum price floor for the MSC. And then 101, an important paragraph. While it is correct that higher prices resulting from a multilateral interchange fee do not in themselves mean that there's a restriction on competition. It is different where such higher prices result from a collective agreement and are non-negotiable. And the last two sentences of paragraph 103, the comparison is in the counterfactual. The whole of the MSC is open to competitive bargaining. In other words, instead of the MSC being to a large extent determined by a collective agreement, it is fully determined by competition and is significantly lower. So now we come to the interchange fees regulation. An important regulatory intervention in 2015. The European Union, as my lawyers have seen...
Can I just just want to understand this concept of the prohibition on ex post pricing, which in the end amounts to what they call settlement of power, as I understand it.
Yes.
So is the idea, going back to the kind of hold-up problem, that ex post pricing would be an issuer saying, well, I'm only going to pay you 99% or something? Is that really what it amounts to?
No, in the whole, the zero MIF, the settlement of power prohibits the issuer from charging an interchange fee. Sorry, perhaps I misunderstood the question.
Well, I'm just trying to understand what they mean by ex post pricing as opposed to zero MIF.
Sorry, I think the word ex post pricing there means pricing imposed by the issuer following or in addition to the actual price that the merchant has charged the customer, the settlement figure which needs to be paid to the acquirer by the issuer. Because the way interchange works is that the issuer deducts the interchange.
Yeah, so ex post pricing really means just deducting something from the amount that they pay the acquirer.
Yes.
And so the counterfactual that is referred to in paragraph 93, little 4, is a counterfactual not just where there are zero MIFs, but where there's actually a rule prohibiting ex post pricing.
Yes, the counterfactual.
Because otherwise they could get around it by saying we're only going to pay you 99p.
Yes.
Is that right?
So, well, it is a rule, and it's a rule which prohibits issuers from charging an additional fee or inflating in some way the value of the service they're providing and charging for it, so that they must settle the transaction at the face value of the transaction with no additional charge. And that's the counterfactual which the parties agreed applied, because if the concern was if the issuers were free to charge a price for the privilege of paying the money to the acquirer, they would take advantage of that and drive up their price, however labelled, to an unsustainable level, and they would do so in competition with each other, and it would drive it higher and higher and collapse the scheme. And that's critical, my lord, because when the interchange fee regulation came in, it completely changed the counterfactual, what would happen in the absence of the multilateral interchange fees. Because as you've seen in the papers, in the IFR, dealing in a regulatory sense with this whole issue of interchange, the European Union enacted caps at levels designed to benefit merchants and consumers, socially optimal caps. And as a result of this interchange fee regulation, which constrained issuers from setting interchange fees even unilaterally above those levels, Visa and Mastercard sought to plead new counterfactuals in the June case, the same counterfactuals which were rejected by the tribunal in the judgment before my lords. And we see that at page 702, that's paragraph 23. And my lords, could you read paragraphs 23 and 24 to yourselves? That tells you how Visa and Mastercard put the case before the Court of Appeal in June, and indeed before the tribunal when they sought to plead these counterfactuals. So the claimants in June resisted these amendments on the basis that they were unarguable as a matter of law. And that's significant in the context of this application for permission to appeal and the concern expressed by Lord Justice Green that we may be seeking to re-argue factual issues. The claimant's case in June was, regardless of whether the UIFM or bilateral agreements would likely have happened absent the MIFs, these counterfactuals were not open to the defendants as a matter of law. Now, the tribunal rejected that argument and the claimants appealed, and we see at page 702, at paragraph 27, the two grounds of appeal which the claimants raised, and they are both points of law. Looking then at paragraph 27, counsel submitted first that the tribunal had failed to analyse correctly the competition concern which had led the courts to find in the Sainsbury's litigation that the appropriate counterfactual was a no default MIF with settlement at par. And secondly, the tribunal had erred in finding that the counterfactuals proposed by the schemes would not involve collusive or collective arrangements, and so would not involve a restriction of competition. And we will see those two arguments again when we come to the tribunal judgment. But just over the page, see how the Court of Appeal addressed those legal points. Paragraph 28. Counsel for the claimants emphasised that the rules providing for the MIFs at issue in the Sainsbury's litigation had been held to be restrictive of competition because they had the effect of setting a minimum price floor for the MSC, while in the counterfactual, the whole of the MSC would be determined by competition. Citing the Supreme Court in Sainsbury's, the argument was that the Supreme Court judgment in Sainsbury's was determinative as to the appropriate counterfactuals in our case. In paragraph 29, counsel submitted the same competition concern arose both before and after the introduction of the IFR, and regardless of whether interchange fees had been capped. The counterfactuals proposed by the scheme would involve the same anti-competitive conduct as has already been held to be unlawful in Sainsbury's in the Supreme Court, namely the collusive imposition on merchants of an artificial fixed cost that sets a floor for the MSC. It's essential that the counterfactual removes the anti-competitive vice identified in the actual, but neither the UIFM nor the bilateral's counterfactual would do so. Pausing there, the argument was because these new counterfactuals also led to a restriction of competition in the acquiring market, they were impermissible. We turn please to page 706 and the Court of Appeal's analysis. First,
Which paragraph?
forgive me, it's paragraph 36. First, but before we read 36, I just want to bring the court up to my lords up to speed. We've already seen that the Court of Appeal examined the legal function of a counterfactual in the Capone Care case. The Court of Appeal had to remove the measure in question and ask what was likely to happen in the absence of the agreement. And they had to examine what the counterfactual had been determined to be in the Mastercard litigation. But then, my lords, if you read the last three sentences of paragraph 36, it explained, first they addressed why settlement of power had been adopted as the counterfactual before the IFR. The prohibition on ex post pricing was, in the circumstances, not only economically viable, but also plausible, indeed likely. Lord Justice Newey said this: the Court of Justice was not, therefore, saying anything about whether a counterfactual has to ensure better competition. It's no function of the counterfactual to ensure that the outcome generates more competition in the market which is said to be harmed. Then paragraph 39, we've already read about the hold-up problem. Sorry, over the page 707. And since I know my lawyers are familiar with this, I'll skip down just below the halfway point where they pick up, after citing Capone Care, plainly, a counterfactual that would itself breach competition law could not be an appropriate one. Subject to that, however, the counterfactual should reflect what would be likely to have happened if the measures at hand had not existed. In paragraph 40. Now this paragraph is a bit tricky, my lords, because it contains submissions of counsel and judicial findings. I'll take it slowly. It starts with the submissions of counsel. And about a quarter of the way down, there's a reference to that being so with the IFR. The Supreme Court judgment in Sainsbury's can no longer be determinative as to the correct counterfactuals. But then this, if, and I submit that this is a judicial finding, if, as Visa and Mastercard say, their schemes would be likely to have adopted the UIFM and the bilaterals counterfactual without any prohibition on ex post pricing, those will be the right counterfactuals to consider. And then paragraph, I'm so sorry, there is no requirement that the counterfactual should remove the concern, problem or vice which exists with the measures in force. The position is rather that if the competitive concern, problem or vice would persist in the counterfactual world, that indicates the measure in question does not itself restrict competition. The Court of Appeals...
For my own part, I would read that as a summary of counsel's submissions, the whole of that paragraph.
My lord,
But
I don't need to persuade you today that those are judicial findings, because first of all, I'm concerned with showing that it's a point of law at issue here, and an important one. But the findings come in the next paragraph on any view. Because the reference is made by Justice Newey to counsel submission under Capone Care that it's imperative that a counterfactual removes the anti-competitive vice identified. And that's a critical submission because it's the same basis for the finding we'll come to in the judgment. The judge says, Lord Justice Newey says, to my mind, Capone Care does not support that proposition. And Ms. Smith does not cite any other case in which it has been held that a counterfactual can be appropriate only if it would remove the competitive concern, problem or vice. More than that, it seems to me that it could make no sense for there to be such a requirement. As counsel for the defendant said, counterfactuals are used to test whether a measure restricts competition. If it were the case that any counterfactual resulting in a continuing competitive concern, problem or vice was to be ignored, the exercise would fail in its purpose. If a competitive concern, problem or vice arose with the measure in question, it would inevitably be found to be restrictive of competition, since any counterfactual which allowed the issue to continue would be discarded.
well, it's essentially an argument about circularity.
Yes.
You just go round in a circle. You could never have a counterfactual which would work because it would always contain the same vice. Is what you're saying.
Precisely. And that finding, that analysis is an analysis of law by Lord Justice Newey, rejecting the submission made by the claimant. Then at 42, in short, I don't consider that claimants can impugn the CAT's decision on the footing that it failed to analyse correctly the competition concern, which had led the courts to find in Sainsbury's that the counterfactual was a no-default myth. As the CAT appreciated, it needed to ask itself about the likelihood of the schemes having adopted these counterfactuals once the IFR came into force, and the fact, if it be one, because it was still, this is a summary judgment application, it still had to be determined as a matter of fact if the counterfactuals would be adopted. The fact, if it be one, that the counterfactuals would not dispose of the competition concern, that would be a reason for concluding that the rules providing for MIFs were not themselves anti-competitive, not a basis for rejecting them. And that goes directly to the point made by Lord Justice Miles, why the claimant submission, as I'll come to, the tribunal's approach, is wrong in law, not least because of its circularity. That was the first ground of appeal. Now the second ground of appeal, there were two in June, And this is very important because the claimants in their submissions to my lords say that the tribunal was right to find that these counterfactuals themselves involved collusive arrangements. First of all, paragraph 43 gives you the tribunal's judgment, which the court upheld. We think it's clear that the bilaterals counterfactual would not involve any restriction of competition, since under that scenario the interchange fee is not determined by a collective agreement. As far as counsel sought to argue that the UIFM counterfactual was a restriction of competition because it depended on a common scheme rule, the very same submission made to your lordships by my friend in his note, we do not accept that submission. The restriction arising from the current rule is that it provides for a commonly determined default level, a positive myth that applies as between all issuers and acquirers. A rule that enables each issuer independently to determine the level of its interchange fee is not restrictive of competition. And the Court of Appeal agreed with that legal analysis. Over the page, please, 709, the Court of Appeal cited fundamental principles of competition law. That Article 1011 has no interest in unilateral action by undertakings, regardless of the consequences in downstream markets. It is only concerned with collusive conduct. And the Court of Appeal cited the Court of Justice in the landmark Sucre Uni case, top half of the page, indented paragraph 173, just halfway through that. Each economic operator must determine independently the policy it intends to adopt in the market. 174, this requirement of independence does not deprive economic operators of the right to adapt themselves intelligently to the existing and anticipated conduct of their competitors, but it strictly precludes direct or indirect contact between operators, the object or effect whereof is to influence the conduct on the market of an actual or potential competitor, or to disclose to the competitor the course of conduct they themselves have decided to adopt. Paragraph 46, as was stressed by counsel, the mere fact that the UIFM and the bilaterals counterfactual might, if Visa and Mastercard are right, result in all issuers raising interchange fees to the levels allowed by the IFR, does not of itself demonstrate that the UIFM and bilaterals counterfactual involve collusion. And that, my lords, is a statement of law, applying the authorities and principles that have been set out by the court. And then over the page 710, paragraph 48, the conclusion. I don't accept that the tribunal ought to have found that the counterfactuals proposed by the schemes would involve, I would say, necessarily collusive collective arrangements, but I wouldn't exclude the possibility of the claimant succeeding in establishing at trial one or both of the counterfactuals would involve such arrangements. It's impossible to arrive at such a conclusion now on a summary basis. So we say that these legal findings were binding on the tribunal, binding, in fact, on your lordships, but even if they're not binding, whatever reason, they're correct in any event and squarely raise important points of law, which we see in the judgment in this case. I could ask the court to go to that in the core bundle. And while we go to it, I should say that in the trial, there was no suggestion of any additional collusive arrangements between the issuers beyond the concerns which the claimants had raised before the Court of Appeal in June. There was no suggestion of tacit information exchange or collusive conduct. Nothing of the sort was alleged or found by the tribunal. And the tribunal appeared to accept, and there's no need to turn up these references, that if the counterfactuals were lawful, they would have been adopted. And in those counterfactuals, the interchange fees would have ended up being set unilaterally at the level of the IFR. But the tribunal rejected them as bad in principle. And for that, my lords, can you go please to page 226 of the core bundle, paragraph 154. Here, the tribunal is dealing with the objective of the counterfactual. its legal function. And at the bottom of paragraph 154, last sentence, Ms. Justice Marcus Smith says, in order to determine the adequacy of the counterfactual, it's necessary to be clear what mischief needs to be removed. He says at 155, the answer is provided by what he calls the prior record, including the Supreme Court in Sainsbury's. And then 156, very bottom of that page, he's referring to paragraph 93 of the Supreme Court judgment. And he says that paragraph not merely articulates what the court considered over the page the counterfactual to be in the case before them, but also sets out the essential infringing conduct, the effects of which need to be measured. He's referring, we would say there, that must be a reference, should be a reference to the infringing conduct, which needs to be removed, the collectively set MIF, and the effects which are alleged to be caused by the collectively set MIF. And at 157, he sets out the essential infringing conduct, and we see the beginning of the legal error here, because little 1 refers to the MIF itself, the collectively set MIF, the MIF determined by collective agreement. Sub 2 refers to the fact that the MIF does not enable acquirers to negotiate a different MIF, it's imposed on them. And 3, as a result, a non-negotiable floor is created in the structure of the MSC, which inhibits competition between acquirers. And now we have the error as clear as can be in paragraph 158. These findings define the mischief that any counterfactual must resolve in order to be fit for purpose. And when the tribunal says resolve, it means remove. The tribunal found that no legitimate counterfactual can lead to a floor under the MSCs in the acquiring market. And that is the same legal argument which the Court of Appeal rejected in June, that the counterfactual must resolve the vice in the acquiring market. And that plainly misunderstands the purpose of the counterfactual. It is important, as the court said in Sainsbury's and June, to identify separately and not to confuse the relevant measure that needs to be removed and the effect or vice or competition concern which it is suggested those measures cause.
It's 3 particularly you're complaining about,
Yes.
1573.
Indeed.
Yeah.
But 2 also refers to the fact that the MIF is imposed on acquirers and prevents competition between them. So it's 2 and 3. 3 is the most obvious one. Because 2 is an effect of the MIF.
But if the counterfactual is determined by the collective agreement, is that a problem with the counterfactual? I mean, as I understand both of the scheme's cases, they're saying that this is not imposed by a collective agreement in the counterfactual world.
Yes.
Because ultimately it's a matter between the issuers and the acquirers.
Yes. Yes, exactly. My Lord.
Which is essentially part of the second ground of appeal that was considered in June.
Yes. Because the tribunal made 2 errors. The first was to misunderstand the function of the counterfactual, which is simply a question of causation. Of course, it is then necessary to ask, does the counterfactual proposed itself necessarily breach competition law? Does it involve a collectively set MIF which has these effects? And is there an agreement with the object or effect of distorting competition? So you must ask the second question, which is whether these MIFs, whether these counterfactuals, are themselves anti-competitive. That's the next question.
Because that would exclude them.
I'm so sorry?
That would exclude them as proper.
Yes, it would exclude them, indeed. Only a lawful counterfactual may be permitted. But the tribunal's first error was to completely misunderstand the function of a counterfactual. And that's an error, a plain error of law. falls into the same circularity problem that the Court of Appeal identified in June. And you'll see nowhere here any analysis of the Court of Appeal's judgment in June. It was completely ignored by the tribunal. And we ask ourselves, how do they go so far wrong? What was the basis?
Before we do that, I mean, on its face, your submission seems correct that by referring to these findings as defining the mischief, it includes that the mischief, one of the mischiefs is that if there's a flaw in the MSC, then that's itself a problem.
Yes.
And has to be removed. Was that carried through, however, when the tribunal reached its decision on the facts? Do we see that being carried through?
Yes, the tribunal applies this counterfactual. This counterfactual. Sorry, this decision to reject the scheme's counterfactuals is what allows the tribunal to make a finding that the MIFs ultimately did breach competition law, because they said, because these counterfactuals are impermissible, the only permissible counterfactual is the zero MIF settlement department.
What I mean perhaps is, do we see that error being repeated anywhere else in the judgment when the tribunal comes to
Yes.
explain why
Yes.
this counterfactual is offside?
Paragraph 190, in countless places, my lord, but I'm told to go to 190. You'll see it when we come to, I was going to take you through the judgment and show you the second error, but 190, this is where they're dealing with the UIFA in particular. These are the reasons, the specific reasons given for rejecting the UIFA. And at 190, we see the first, which is the mischief which the counterfactuals must address is the elimination of the rule and the imposition of a different default. And this is important, such as interchange fees that are not freely negotiated, does not meet the requirements specified by the Supreme Court. So the tribunal is saying there, we are rejecting the scheme's counterfactual because it does not secure free negotiation of interchange fees.
Right.
It doesn't allow the acquirers to insist on zero MIF if that's what they want. And that is the restrictive effect which the counterfactual is supposed to identify, or identify the lack of it. So I'm grateful to Maya, that is a very good example of how the counterfactual infected the final.
But in fact, that paragraph has a cross-reference back to 157 in the footnote.
Yes.
As described. And then it refers back to
Absolutely.
155 to 157.
I'm obliged to Miles for that. So we ask ourselves back at paragraph 158, how did the tribunal go so badly wrong? And we look for reasons. Subparagraph 1, the tribunal says these findings represent the independently arrived at conclusions. In particular, the findings are absolutely consistent with the market definition found in this judgment. Now, that market definition was disavowed by the other two tribunal members. Just for your note, that's paragraph 273 and following. Over the page, Mr. Sir Marcus Smith says, second reason for his approach, the weight to be attached to these findings, which arise out of the prior record, is enormous. Supposing there, which bits of the prior record we ask, because he's defined the prior record, as you saw in the skeletons, as including everything, including statements of objections, allegations by authorities, judgments that are binding, judgments that aren't binding. To the extent we are looking at legally binding authorities, they flatly contradict the notion that the counterfactual must not produce the same effect as the impugned measure. Then at 1582, Mr. Sir Marcus Smith says in the second sentence, the question doesn't arise anyway because these are findings of fact independently made. But that's also wrong. The function of a counterfactual, what it's supposed to do, is a question of law. Isolating the measure which is alleged to restrict competition and removing it, and only it, from the counterfactual, that is a legal requirement. And we see how the tribunal applied that in the case of the UIFM. So now we will go to the paragraphs that we've just seen. Page 243. This is where the tribunal applied that counterfactual analysis to the UIFM. don't know if my Lord Judge Zacaroli has the pagination. It's 243 of
Yes.
the bundle. And paragraph 1891. First, the tribunal said the UIFM counterfactual is dependent on the universal application of the interchange fee regulation, which of course is not universal. Pausing there, that was no part of our case. Obviously, we accepted that the IFM, so the IFR, only applied to certain MIFs, and it was only with respect to those MIFs that we prayed it in aid for the counterfactual. And then he says, and so it fails for the same reasons the bilateral is counterfactual. I'll come back to that. But focusing on the what he calls additional reasons, numbered 1, 2, and 3. We've looked at 1, where he carries across the counterfactual. And then we come to, on page 245, under heading C, in the scheme zone case, the UIFM counterfactual makes matters worse, not better. And this is the beginning of the tribunal's second error of law. Because here, and in the passages that follow, the tribunal found that the new counterfactuals themselves breached Article 1011 because they were a coordinated conduct. And so I'll take the tribunal's heading C and D together. This is where the tribunal found that the counterfactual was bad. The counterfactuals were bad in any event because they themselves were necessarily collusive conduct. And paragraph 194, the tribunal says, the UIFM involves moving the benign dictator role away from the schemes, where at least there can be said to be a balancing role, I'll come back to that, to parties, namely the issuers, whose interest it is to push the interchange fee up. And I repeat, my lords, the paraphrase, whose individual interest it is to push the interchange fee up. He says that means the trend of the interchange fee would be upward, with the acquiring market paying even more to the issuing market. Replacing the scheme's benign dictatorship with an issuer-driven price is not going to reverse this trend, but exacerbate it. The only effect of the UIFM is to remove control of the interchange fee away from the schemes towards issuing banks, I add towards individual issuing banks, who will negotiate as they should in their own interests, their own, I add, individual interests, and without any neutrality or benignity, should such exist. And we say, yes, those findings demonstrate why the counterfactuals are not breaches of Article 1011, just as the Court of Appeal found in June. Because as a matter of law, Article 1011 is not engaged at all. The first key fact in the Supreme Court judgment, paragraph 93, does not arise. The MIFs are not set collectively.
Unless they're coordinated conduct.
Well, the tribunal is finding here that the interchange fees in the UIFM are being set by the issuers individually in their own narrow, selfish self-interest. He says that's problematic because the prices for the acquirers will go up and the acquirers will face the same problem in the acquiring market. That's his concern, my lord. It's not that the issuers are in some way coordinating and in some background way they're anticipating each other's price moves.
Well, he goes on to say that they are.
Well, 195.
At 196. And so
Yes.
on. I mean, the reason I say that is that the idea that the idea behind your counterfactual has to be that it's not coordinated conduct, doesn't it? Because
Yes.
otherwise it would be an agreement between a whole lot of people, namely the issuers.
Yes.
And that itself would then be arguably anti-competitive and therefore not a good counterfactual.
Yes, but we must be clear about what we say is the agreement. The Supreme Court explained that the agreement is the collectively set MIF. The problem that the problem is caused by the fact that the interchange fee is multilateral. It is a collective MIF. That is why Article 1011 is triggered in the first place. The tribunal's concern was not that the issuers were some way coordinating and was never alleged, there's no finding. We'll come to 196, my lord, but just before we do, 195, the concern here is revealing. The president, as he was then of the tribunal, says the counterfactual case is worse than the actual. It's for this reason the UIFM is so dependent on the regulation. It's necessary to have some constraint on the issuing market, and the virtue of the IFR is that it removes the schemes. It removes the schemes from the setting of the default. He's acknowledging that the MIF is no longer set by the schemes, no longer set collectively. But he says it's bad because now that it's set individually by various issuers, acquirers are possibly even worse off than they were before. He says at the end, all the UIFM does is replace an arguably benign dictatorship for a rapacious one, controlled only by the limited ambit of the IFR. And again, it is absolutely central to competition law and Article 1011 that that provision and that prohibition has no interest in rapaciously high prices if they are set by individual undertakings acting unilaterally. But then we have the following finding under D, that the UIFM is itself coordinated conduct.
Just before you do that, what does he mean by it's the default that must be removed? The sentence you highlighted.
He understands the default there to be that in the UIFM, there is, he thinks, a kind of default, which is that the acquirers will just end up paying the IFR level of the MIF. So the default in the sense that they all know, and they have no choice because of the bargaining power of the issuers, that they will pay interchange fees at the IFR caps. So in substance, there is a default, but it's a default to whatever the individual issuers decide to price individually.
But it's not a default by reference to any rule that exists in the UIFM.
Absolutely not, and that's central, my lord, because the UIFM does not say you must pay the IFR price, the capped price. The UIFM does not steer anyone towards anything.
What does what's the rule in the UIFM?
The UIFM is, in the absence of a bilateral agreement, the individual issuer will notify Visa of its interchange fee, the fee that it wants to perform interchange. And Visa will plug that figure in to the system and just move the money according to the demand of the individual issuer in the absence of a bilateral agreement with the acquirer.
It doesn't say there has to be a unilateral fee.
It simply says if there's no agreement, the issuer will decide and the issuer will plug in its fee. I mean, I'm paraphrasing, but the key thing is that the UIFM does not steer anyone towards anything. It simply says, in the absence of a bilateral agreement, the issuer will decide, and whatever figure it decides will be plugged into the scheme.
But if the issuer hasn't notified its fee,
Yes.
and there's no bilateral agreement,
Then
what
there's a
then
zero,
happens on your...
zero MIF. It'll be if the issuer does not notify a fee and there's no bilateral agreement, then Visa will apply a zero MIF.
So there would still be settlement through the system, as it were.
Yes, but it would be at par, which
And no post
no ex post pricing. Exactly.
pricing.
Yeah. So as far as Visa is concerned, it will either apply the bilaterally agreed MIF or a zero MIF unless the issuer, in its own best interest, says, no, I want to be paid this. This is the interchange fee I want, and it notifies Visa of that. And that will be the...
And how will Visa know if there's a bilateral agreement
It needs to be notified. The rule requires Visa to be notified of a bilaterally agreed.
as well?
Yes. I mean, there was always provision in the rules for bilaterally agreed MIFs, and there was always provision in the rules for Visa to be notified, but it just didn't happen in practice because of the hold-up problem.
I mean, what I understand the judge here to be saying is that, okay, that's all very interesting, but as a matter of absolutely obvious economic reality, where this will end up is at the cap level.
Yes.
Because it will always be in the interests of issuers to say, right, here's our notification of our fee,
Yes.
and it will be at the cap level under the regulation.
Yes.
And so I think what he's saying, as I read it, is that that is, in reality, under this system, a default.
It's a default in a sense. It's defaulting to market forces and the individual price setting of individual undertakings acting unilaterally. But that, my lord, that is precisely what the Court of Appeal in June said was not a restriction of competition contrary to Article 1011, and it could not possibly be. Because unilateral action, regardless of its harmful consequences, is not the concern of Article 1011. That is, there may be an abuse of dominance, there may be a regulatory intervention, it's a different issue. And what we see, and it's true, my lord, there's no need to take you to paragraph 197 now, because that says what you said as to the concern of the tribunal, that in reality everyone knows that the individual issuers are going to set their interchange fees to the cap. But that is by definition not a collective act. And the Court of Justice in Zacaroli not only said that competition law is concerned with collective action only, but even if individual undertakings adapt themselves intelligently to their competitors and adjust their conduct accordingly without contact, that is also perfectly legitimate competitive conduct. And what the tribunal did here was heretical in competition law terms. This was a very serious error because it fundamentally misunderstood the function of Article 1011 in order to address a policy concern that the tribunal had with individual issuers setting their fees higher than the tribunal would have liked.
When you say, sorry, can you tell me whether this is right? Actually, as I understand it from your description of the rule, the default in your case is actually zero MIF.
Yes.
If there is a default.
If there is a default, it's to the zero MIF, yes.
The default rule isn't IFR cap.
No.
That would come about by intelligent action by issuers acting in their own interests.
Yes.
Right.
The third, that really is good enough for my purposes. But for the sake of completeness, there was a third error of law that the tribunal found that the counterfactual had to work for all MIFs, not just those to which the IFR applied. It's a very strange legal finding by the tribunal. It's completely unprecedented in the extensive body of law relating to interchange. We see that at page 242. Paragraph 184, and this again is supported by our friends in their note to the court. At 184, paragraph 184, the counterfactuals propounded by the parties of necessity have to be default MIF neutral. They can't apply to transactions involving one type of MIF but not to transactions involving another type of MIF because a merchant will accept cards in transactions involving all kinds of default MIFs. First of all, as I said, it was never our case that these counterfactuals applied to all the MIFs. Obviously, they only apply to the ones where the IFR applies. But to say that the counterfactual must be MIF neutral makes no sense at all. We know from Westover, you've seen that authority, that the measure restricting competition is the particular MIF in question, not just the rule allowing MIFs. And the counterfactual for one MIF may be very different from another. Because when you take away the impugned measure, the regulatory or the factual circumstances might well differ significantly between them. The tribunal didn't find that the IFR had to be disregarded as a matter of law, which was the claimant's case before the tribunal. So if you can take it into account, if you can take into account the IFR then the court must do so in respect of MIFs where the IFR applies. And that's saying no more than that relevant factual circumstances for one type of interchange fee may be different from another type of interchange fee. Just to explain, for interregional MIFs, for example, the revenue that they produce for issuers is much higher than domestic MIFs, and the use case for those is different. Tourists and travelling businessmen incur those MIFs. If you remove them, the consequences, what happens in the market may be different from the consequences where the much lower but much more widely applied domestic MIFs are reduced. It's no more than saying the counterfactuals may differ depending on which MIF is in issue. And it's hard to understand where this idea of the tribunals came from. We saw paragraph 184, and the tribunal seems to think it may be rooted in market definition and the fact that merchants take all types of payments. But the fact that merchants want to accept all transaction types doesn't change the legal analysis. If one interchange fee turns out to breach Article 1011 because of the counterfactual analysis, it's for the scheme then to justify it, and the court will set a lawful level. It's possible that in the same package of MIFs, another MIF may ultimately produce a different legal analysis. From the merchant's perspective, all that will change is the lawful level which he or she is paying via their acquirer to the issuer. There's no authority, no support, no suggestion of where this idea has come from. It's obviously wrong. So in conclusion, on this grant of appeal, we say the tribunal made a very serious error of law, and at the very least we ought to have permission to argue this fully before my votes. I've only dealt with the UIFM. My friend wants to deal with the bilaterals counterfactual. I'll hand over to him.
My Lord, before the tribunal, Mastercard submitted as an alternative that it was clear in the light of June that the bilaterals counterfactual was lawful, that it was the correct counterfactual because on the evidence it was what Mastercard would likely have done, and based on the agreed expert evidence, interchange fees would not have been materially different in that counterfactual, which meant that MIFs were not a restriction of competition. And none of the reasons given by the tribunal for rejecting Mastercard's case on this issue is consistent with authority or can withstand scrutiny. You've seen the summary of the counterfactuals advanced by the schemes in the June Court of Appeal decision that Mr. Kennelly showed you at paragraphs 23 to 25. Mastercard led evidence in trial 1 that in the absence of MIFs it would have implemented either the bilaterals or the UIFM counterfactual, and that evidence was almost entirely unchallenged. We refer to the key written evidence on this in our paragraph 55 of our skeleton argument. And we note for completeness in footnote 11 that a point was put in cross-examination about needing millions or billions of agreements, but that was put on a mistaken premise. Now, my learned friends have not disputed that in their response, and it's important to note, and your Lordship can take it from the summary in paragraph 55 of our skeleton, that the evidence was not limited to saying that Mastercard would have liked to have pursued these options. It covered in detail why the options were commercially viable and why they would have been implemented. And I've emphasised that evidence because, as I'll come on to show you, in fact, Mr. Justice Marcus Smith paid no regard to the evidence of Mastercard at all. He didn't have reference to it. And that's because he decided that it was an abusive process for Mastercard to even argue the bilaterals counterfactual. And that decision, one of his 3 reasons for rejecting the bilaterals counterfactual, actually that particular reason was the principal reason and infected the others. So the 3 reasons he gave were that Mastercard's reliance on the bilaterals counterfactual involved an abusive process, or it involved a disguised default rule and was destructive of the scheme. And the third reason, as Mr. Kennelly's already identified, was that the counterfactual only applied to some of the challenge myths. And those reasons are in 168 of the judgment. And in relation to the second and third reasons, the Chair seems to have proceeded on the basis of a fundamental misunderstanding or misrecollection of what the bilateral's counterfactual was. And it may be that that follows from having ignored Mastercard's evidence or from the delay in producing the judgment, but it is an area where the judgment is not safe and reference to the evidence would have made a difference to the outcome. Can I start with the key reason given by the tribunal for rejecting the counterfactual? This is abuse of process. And if he was wrong...
Sorry, I think there may actually have been 4 points that the judge made in 168, because although it's in 3 sub-paragraphs, the first of them actually has 2, because he says first that it's either a disguised default or it's so destructive of the scheme
as to be
as a
unrealistic.
whole.
I'll address both of those,
Yeah,
my lord.
all right.
They're essentially the same argument, so I'll address them.
Okay.
The key argument is the 1 and 2, which is the abuse of process argument. And may I start with that? And the reason it's key is because it was on that basis the tribunal decided not to consider Mastercard's evidence on the issue. And if the abuse finding is wrong, then the tribunal's treatment of the entire issue is fundamentally defective. And the reference for the decision to disregard the evidence, which I'll come to, is at 183 of the judgment. Now, at paragraph 67 to 69 of our skeleton, we set out 3 independent reasons why the tribunal's conclusion on abuse was not open to it and is wrong in any event. The first point is that no abuse allegation was made at trial, and there are 3 aspects to that. The first is that the claimants did not allege that Mastercard's bilateral case was an abuse. The case was not pleaded, nor was it advanced in argument. Secondly, it was not put to Mastercard's witnesses that they were contradicting any evidence given in prior trials in relation to bilateral agreements. And thirdly, at trial, the tribunal did not raise even the possibility that the bilateral's counterfactual was an abuse of process with Mastercard, and Mastercard was given no opportunity to address the allegation in oral or written submissions. And this, my lord, was a very fundamental procedural unfairness, because the issue of the appropriate counterfactual was central to the outcome on post-IFR myths, in relation to which huge damages claims have been advanced against Mastercard and Visa. And if Mastercard is right about the appropriate counterfactual in relation to these myths, there is no infringement and no claim for damages. So to reject Mastercard's case on this issue on grounds that were not alleged or argued or raised during the trial involves an extraordinary departure from fundamental principles of procedural fairness and natural justice, and takes this court into the territory of the phones for you analysis. The second point is that the abuse argument had in fact already been raised and rejected by the tribunal, a differently constituted tribunal in these proceedings, in June CAT. And that was binding on the tribunal, and it was not open to the tribunal below to reach a different finding. May I show you the decision of the CAT in June, as we've looked so far, I think, at the Court of Appeal. And if we could start, please, it's the authorities, tab 8, at page 65, paragraph 48. So the appropriate counterfactual in light of the IFR was not an issue considered in the early cases, including Sainsbury's, because the counterfactual was one where the IFR hadn't been brought into force, so it wasn't part of the counterfactual. And that's what the CAT says at paragraph 48. So no argument had been run in the prior cases by the defendants as to the IFR. And so we read, I think it's about 8 lines up from the bottom, since the arguments which Visa and Mastercard now wish to advance were not raised, still less addressed in either AAM or Sainsbury's Visa proceedings, the judgments in those cases are not authority on this point, and there can be no question of issue estoppel or abuse of process in Visa and Mastercard seeking to run this argument as against the present claimants. So there's a clear finding that the counterfactual that Mastercard advanced at trial 1 had not been advanced previously, and it was not an abuse for it to be asserted now. Paragraph 49 then makes the point that where there are materially different circumstances, a different counterfactual may apply. And that follows from the principle set out by the CJ, EU and Mastercard in the passage quoted at the end of the paragraph. Analysis of a putative restriction of competition has to take place in the particular economic and legal context in which the undertakings concerned operate. Mastercard's expert evidence below concluded that the introduction of the IFR caps fundamentally changed that economic and legal context and made it viable to do without default scheme rules in relation to interchange fees, leaving it to acquirers and issuers to agree the terms on which they settled the transactions. And it was agreed between the experts that the schemes would have preferred to adopt either the bilateral counterfactual or the UIFM rather than settlement at par, and there was no disagreement between the experts as to whether it was economically feasible to do away with default scheme rules. And just for your note, that's in the supplemental bundle, page 39, under issue 3, the joint expert statement. If we go back to the tribunal's decision in June CAT, at paragraph 50, page 656, we can see from that paragraph that the then active claimants tried to argue that Mastercard's bilateral counterfactual was inconsistent with its opposition to the Sainsbury's bilateral counterfactual devised by the CAT. And the argument was therefore that Mastercard's counterfactual now should be rejected at the outset. And that was not accepted by the CAT in June. And one can see that if you read from 51 through to 53. Now, the claimants did not appeal that allegation and contend that it was an abusive process for Mastercard to advance the bilateral's counterfaction and lead evidence to the Court of Appeal in June. And on the issues that were appealed, the Court of Appeal rejected the legal arguments raised by the claimants and confirmed at paragraph 42 of the Court of Appeal decision, which is at tab 10, that the task for the tribunal at hand would be to ask itself about the likelihood of the schemes having adopted the UIFM and the bilateral counterfactual once the IFR had come into force. So that's what the Court of Appeal said was the task for the tribunal below. And so it was completely inconsistent and inappropriate for the tribunal of its own volition below, contrary to that binding decision, to decide that in fact Mastercard advancing the bilateral's counterfactual at trial was an abusive process.
So was the, just so I understand this, was it actually being argued before the CAT in this June decision that it was an abusive process?
Yes. Yes, it was.
Where, I mean, I've seen references to abusive process. Where does that?
I will find the. The applications, you can see, my lord, from paragraph 23 was for summary judgment.
Yeah.
On the basis that it had already been determined in the Sainsbury's proceedings. And 29 sets out the issues. And then the relevant passages start dealing with why, as I've shown you at 40, why it was not, we were not barred, and 48 and 49, and 50 seems to be where Miss Smith objected to it on the basis it was necessarily inconsistent with the Court of Appeal's rejection, but the finding that the counterfactual involved a series of bilateral agreements.
And what Marcus Smith, Mr. Justice Marcus Smith seemed to have thought was abusive was actually advancing a case that was inconsistent with expert evidence that had been given in the earlier proceedings. Is that?
Well, that's one of the things he says. He refers to it just overall as an abuse to advance an inconsistent case. And he also, you're right, says that the evidence was different. But 2 points on that. The case that was advanced previously by Mastercard was that it would not have been possible to have the bilateral counterfactual in the absent when there was no IFR. So the IFR didn't exist at the point in time where Mastercard was saying, in response to a counterfactual invented by the CAT, that wouldn't be a likely outcome. And the whole point that is being made by the June CAT is that matters had moved on, and it was a different counterfactual that was now being advanced in light of the IFR. So the first point is that the judge seems to have elided the two counterfactuals without recognising the distinction. The second is that this point had already been considered by the June CAT and not appealed. And the third is insofar as the expert gave different evidence. Well, first of all, it's on a different counterfactual. Second, he never put it to the expert. And so the expert was never given the opportunity to explain that. So, my lord, the third reason why the tribunal's finding on abusive process is that can't stand is that it's actually just wrong on in itself. And that's because it wasn't inconsistent, the bilateral's counterfactual, with Mastercard's case in earlier proceedings, the reasons I've given. And again, that was set out in the passage in June CAT. And then can I turn to the two other reasons given by Mr. Justice Marcus Smith for rejecting the bilateral's counterfactual? And I can do so briefly because it said that they follow from the abuse point. Can we look at paragraph 183, please, which is at page 242. So this is where the high point, I think, of his conclusion. He says it's an improper collateral attack on the prior record, so serious as to amount to an abusive process. Now, just pausing there, that's quite a remarkable finding to make in relation to a party without ever giving the party the opportunity to address it. It's also wrong for the reasons I've given, but the critical point, for your Lordship's purposes going forward, is at the end of 183, you see, for these reasons, the evidence adduced by Mastercard on this point, i.e. the bilateral counterfactual, is not referenced. This point was not open to Mastercard. So the judge appears to have just simply put aside or left out of account the evidence of Mastercard on counterfactual because it was an abuse for Mastercard to even pursue it. So in a sense, we don't need to go further because we say everything else is vitiated by this particular approach. But the claimant's response to this point is at paragraph 4 of their response. And that's at tab 4 of the bundle. So I think it's maybe 5, tab 5, thank you. And what is said is here, that paragraph 4, page 90, ground 2b, the CAT's finding that the bilateral counterfactual was unrealistic was open to it on the evidence. I'll come to the relevant paragraphs, but it's unclear how that can be found in circumstances where it said that he didn't have regard to the evidence. And in any case, it said it would have led to the collapse of the schemes, which isn't right. So that's what's said in the response.
And when you look at paragraphs 169 following, which is where he deals with the substance of this point, is it right to say that he doesn't reference any of the relevant evidence?
My Lord, I believe that is right, and one of the reasons is that there's an exchange at paragraph 175, which, I have to say candidly, it wasn't very clear what the judge was getting at, but it showed that he had not understood the bilateral's counterfactual, because he didn't understand that settlement and processing functions didn't have to be carried out as part of the Mastercard scheme. It could be, but it could be carried out by a third party. And he just didn't seem to understand that. And the paragraphs don't appear to reference the note that we put in or any of the evidence explaining how the counterfactual actually worked.
Was that explained, that point about settlement outside the scheme, was that explained in your evidence?
I'll just check that. It was by Mr. Willett. It was explained by him.
If one can put it in try and put it in a nutshell, the reasoning of a judge on this point, as I read it, is that settlement of transactions under, if I can use this, it's all metaphorical, but under the auspices of the scheme was an essential part of being a participant in the scheme. And therefore, if you had the possibility of bilateral agreements which would not be settled under the scheme, as he puts it, that would, I think, as he put it, that would, as it were, destroy the scheme, or another way of putting it would be to say that it's outside the scheme.
Yes.
That seems to be the nub of the reasoning. So what do you say about that?
So the first point is it's just not right. It was always possible to settle and clear outside the scheme by a third party, and bilateral agreements were always permissible. So, and the scheme operated on that basis. Now, in practical terms, issuers didn't at that stage, and acquirers make bilateral agreements, but obviously that was because there was a default MIF. But to say that it would destroy the scheme when it was fundamentally part of the scheme, and the evidence was to the effect that the scheme would happily continue because it had always been possible to do so, and it would be possible for a third party to provide those functions, just misunderstood, first of all, I'm afraid, the nature of the scheme itself and the rules, and secondly, the evidence.
To what extent would settlement outside the scheme carry with it or exclude the possibility of all the other benefits and obligations imposed by the scheme?
It wouldn't, because once you're a member of the scheme, you have to comply with rules, and there are things like licensing and that type of honour all cards rules that are still imposed. It's just simply that those functions of clearing and settlement, which were always available to be done by a third party as a matter of law, they had to be. It just built on that arrangement that was already there in the rules.
And in that scenario, that's to say where there is a bilateral agreement, putative bilateral agreement, would the issuer still be required to pay, i.e. to settle? So there's a transaction, the whole basic idea of the scheme is that a customer uses a card or other facility to buy something. The merchant then hands it over. The merchant then, via the acquirer, seeks payment from the issuer. And the scheme only seems to work if the issuer is under an obligation to pay for that customer, for the underlying customer. So under this hypothesis, which is that you have bilateral agreements, settlement outside the scheme, if I can call it that, is there still some obligation under the scheme on issuers to pay?
Well, the obligation would come from the bilateral agreement made between the issuer and the acquirer if they were not using Mastercard's functions. And this was the other reason why the judge was concerned at 1764 of his judgment, because he was assuming that the issuer who didn't have a pre-existing agreement with the relevant acquirer would simply be able to withhold payment. But the unchallenged evidence before the tribunal was that that couldn't happen and wouldn't happen in practice, because in practice issuers and acquirers would have pre-existing arrangements. And that we set that out in paragraph 74 and footnote 16 of our skeleton argument. And so the concerns that the judge had on the two additional, the scheme collapsing and the disguise rule, weren't right. But also, if he'd had regard to our evidence, which he put to one side, he would have seen that it wasn't right. And on the evidence before him, he couldn't have reached the findings he did. And can I also just pick up on the disguised default MIF rule? I think that's the one point I didn't pick up on. But the first point is it's contrary to the conclusion in June, because the idea that the bilateral counterfactual was objectionable in law on the basis that it would inherently involve a restriction of competition was rejected by the CAT in June and upheld. That was upheld by the Court of Appeal. And the references for that are paragraphs 41 and 51 to 53 in June CAT, Authorities Bundle 8, pages 652 and 656, and paragraphs 41 to 48 in the Court of Appeal, Authorities Bundle 10, pages 707 to 710. The second point is it suffers from the overarching problem I've identified, that the default rule was a restriction of competition. That was a wrong finding and not open to the judge. So therefore, using that as the springboard to saying this was a disguised default rule, it starts from a false premise. And the third point is that it's contrary to Mastercard's evidence. And the only other points in light of the time that I should make are that it's only if the court's against me on those points at this stage I need to address the substance of the conclusion. But what's quite clear from paragraph 164 of the judgment, it is that the chair just didn't understand the bilateral's counterfactual because he understood it to keep in place the requirement that there be an interchange fee as between an issuer and an acquirer, whereas the June CAT decision, and we on argument made it clear, so it's June CAT paragraph 50, that Mastercard's case was that there would be no default settlement rule at all. So, my lord, in the phones for you territory, the delay of itself doesn't make the judgment susceptible to challenge, but it does mean that if there's a flaw identified in the understanding, this court will have regard to the fact that the trial judge may not have been in the best place to make findings. And here we see that the judge simply didn't seemingly understand the counterfactual, and his judgment contradicts prior decisions in the same proceedings, as well as the evidence which he didn't take account of. My lord, in light of the time, I'm not going to try and develop the market definition point, save to say that Mr. Kennelly has given you an example of where it came into play, and we addressed that in our skeleton argument. What I would say is that if your lordship reads that section of the judgment and just has in mind that no party argued for that definition, and in fact the definition of market was largely agreed between the parties and the experts, something that Mr. Tidswell points out, and yet 40 pages of the judgment is devoted to a definition and finding a focal point, which is, with all respect, very hard to understand and follow. And then it does infect the judgment going forward. And it's not right that the rest of the tribunal doesn't adopt it, and there are examples as we set out, but one of which Mr. Kennelly's shown you. I think there may be another that he will show you now.
So I'm moving on to the ground of appeal concerned with the finding of a by-object infringement. We're running slightly behind a time estimate. I'll do my best to get up to 1 o'clock. I may need a little bit of time after lunch. It'll come out of our reply, just to warn you in advance, but I'll do my best.
If you can, please, yeah.
I'm so sorry.
If you can, try, please.
I really will. And I understand that the tribunal has obviously covered this extensively in pre-read. The majority of the tribunal also found that the MIFs infringed competition by object, save for the MIFs set in accordance with the IFR and the ones set in accordance with binding commitments accepted by the European Commission. It was common ground, and the tribunal found that the test for an infringement by object was whether the MIFs were inherently so harmful to competition that an effects analysis was unnecessary. And our case at trial was that the MIFs were not so inherently harmful. And to show you the point, could I ask you to go back to the judgment of the tribunal in the core bundle behind tab 8, at page 291. Paragraph 284. So we said that the MIFs were necessary to achieve efficient card usage by providing an appropriate balancing of costs across both sides of the two-sided market. There's a pro-competitive benefit from the MIFs, which we said was a legitimate objective. And the tribunal saw at 285 an otherwise apparently anti-competitive measure, which is likely to cause harm to justify a by-object infringement, can avoid that outcome if the measure is shown to have a legitimate objective. And it was our case as to balance that on the issuer side, and I touched on this in discussions with my lords, because of the costs involved with issuing cards, a higher interchange fee incentivizes issuers to issue Visa cards, which leads to more card holders, which leads to more merchants accepting Visa or Mastercard cards. on the acquirer side, a lower interchange fee can incentivize acquirers to participate in the system. It encourages acquirers to recruit more merchants to accept Visa and Mastercard cards. And striking that balance between the acquirers and the merchants has always been a key objective of multilateral interchange fees, to avoid the problem, in fact, that we saw in the hold-up issue that the court has seen. And that's a long-standing and well-recognised objective, and as the court has seen, multilateral interchange fees have been under scrutiny by the European Commission, by the UK authorities, and by the courts since 1977. At no point have these multilateral interchange fees been found to constitute a restriction of competition by object until this judgment of the tribunal. We see the reasons they gave. We're still in the judgment of the tribunal. Could we go please to page 173, paragraph 84, sub 3. Here the tribunal is adopting the claimants' written closing, 84 paragraph 84 sub 3. The link between the two markets, the issuer and acquirer market, is that a payment card will have greater value to a cardholder if it's accepted by a greater number of merchants. At the same time, the value to a merchant of accepting a particular type of card is dependent on the extent to which consumers have and use the cards, and the degree to which consumers hold and would use cards belonging to another scheme. And merchants will generally wish to accept a payment instrument readily available to a customer. And at 85, in view of that, the tribunal goes on to say, in the present case, the concern is with the acquiring market, because the merchants claim that the fee charged to them by acquirers infringes competition law. The issuing market's only indirectly relevant, to the extent that there are network effects between the issuing market and the acquiring market, which can properly be taken into account when considering the question of infringement in Article 101 TFEU. And over the page, this judgment is not concerned with whether an infringement can be justified under Article 101.3. Pausing there, the way Article 101 works is that Article 101.1 deals with infringement. Article 101.3 provides the conditions for an exemption to show that an otherwise infringing measure may be justified if the conditions in 101.3 are satisfied. And Mr. Justice Marcus Smith here is saying there may well be benefits, but they are for Article 101.3, and we are not concerned with them because we're dealing with Article 101.1. Accordingly, the contention that markets going beyond the acquiring market fall for consideration is, for these reasons, rejected. The tribunal is saying we will not consider whether interchange fees have as their object positive balancing effects on the issuing market. We are looking only at harm in the acquiring market. And that was, as you will see, a legal error, contrary to the established authorities of the Court of Justice as adopted by the UK courts. Page 273, please, next. We have the conclusions of the tribunal, paragraph 245. I'm so sorry. Page 273, paragraph 245. Is there a by object infringement? The tribunal gives 5 reasons. We'll take them in turn. 1, this is not a case of a default price where market participants can opt out. So the first point is that merchants and acquirers must accept the interchange fee. 2, over the page, the market elasticity of demand is such that the default price can be increased effectively at will by the schemes. The same point, it can just be imposed on acquirers. It goes on, the tribunal goes on to say there are no objectively justifiable criteria. Such criteria might include the discharge, but only of specific and specifically quantifiable costs in the issuing market or in ameliorating negative network effects, but they don't exist in this case. Pausing there, it's never been the scheme's case that the fees discharge specific and specifically quantifiable costs in the issuing market. And that's never ever been found to be a requirement to avoid a by object classification. Then 3, we have our familiar reference to a floor. The myth creates a floor in the acquiring market. And then 4 and 5. There's no purpose to the myth that cannot be achieved through free market interaction between the scheme and issuers and the scheme and acquirers. 2 legal errors there, my lords. The first is it's suggesting that to avoid a by object classification, the restriction needs to be indispensable for any benefits created. And that is confusing the test for ancillary restraints, which do need to be shown to be indispensable, and the test for identifying a by object infringement. But there's a second and more curious legal problem here. The tribunal is talking about the interaction not between issuers and acquirers, which is what we've been talking about, but between free market interaction between the scheme and issuers and between the scheme and acquirers. And although it's not clear, this seems to be a reference to a potential counterfactual which Mr. Justice Marcus Smith himself raised during the course of the trial, but which he then dropped in the judgment. What he suggested was a counterfactual where instead of MIFs, the schemes could adjust the fees charged to issuers and acquirers as to ensure the appropriate incentives for each. And he thought those fees could be negotiated. He rightly dropped the idea. It had never been pleaded or raised in any factual or expert evidence, but it seems to linger here. And just to be clear as to how it was dropped, you go please to page 259. Skip back please to 259, paragraph 212. I'm afraid 2 very confused paragraphs, because in 212 he says during the course of the hearing, Mr. Justice Mark Smith says, the schemes suggested the existence of a further counterfactual, christened the scheme fee counterfactual. We didn't. That was from the learned judge, which he appears to acknowledge himself in the next paragraph, second sentence, when he says, when the tribunal raised the question, it was in order to understand the operation of the market. But the important part is the bottom of 212. He says it would be improper for the tribunal to reach a conclusion in regard to a counterfactual that no party could fairly address, and the tribunal has not done so. But it seems to linger nonetheless in paragraph 245 sub 4 of his judgment. Turning then to the correct legal approach. Those are the reasons given by the tribunal for why it was a by object infringement. It was contrary to the legal test, which is set out in 2 authorities, Carte Bancaire and Budapest Bank, ignored by Mr. Justice Marcus Smith, addressed very briefly by Mr. Tidswell, the other member of the tribunal, along with Professor Waterson. I need to show you Carte Bancaire and Budapest Bank.
Is this the point that for restriction by object, it must be effectively salvious, that it's going to harm competition? You
Yes.
don't need to look at effects. That's the point.
It is. But in fact, what Carte Bancaire and Budapest Bank show you is that in the particular context of interchange fees themselves, this balancing objective means you cannot say it is inherently harmful to competition. There may well be effects which are demonstrated, but you cannot say that it is so inherently harmful that it necessarily harms competition, and an effects analysis is unnecessary. Carte Bancaire and Budapest Bank addressed actual interchange fees, which is why they're so material and why it was an error, the tribunal, in Mr. Justice Marcus Smith's case to ignore them, but in any event not to follow them in the case of the tribunal as a whole. May I take you to Carte Bancaire
Yes,
first?
the reference to those points, or that point, would be helpful.
Yes, so Carte Bancaire, it's in the authorities bundle tab 18. I'm going to take this at a fair clip, my lords. If I'm going too fast, I ask you to stop me. because you need to see the measure in question. If you go please straight to page 1164 in the authorities bundle, that is paragraph 4 of the judgment of the Court of Justice. Paragraph 4, at the bottom of the page, the rule was being described, and in this case, it was a pricing measure, a rule imposed by the card scheme Carte Bancaire. And if you go over the page, you see what the rule was designed to do. Top of the page, 1165, it was designed to encourage members that are issuers more than acquirers to expand their acquisition activities and to take account financially of the efforts of members who are acquiring more than issuing. And the way this worked was it was a financial charge paid by issuers to acquirers, in this case, based on the ratio of acquiring to issuing activity. The idea was too much issuing to get the cash, whereas the acquiring was necessary for the thing to work. And so the acquirers were to be compensated and issuers were to be discouraged from issuing cards in order to restore balance in the scheme. And at the first hole punch, you see that the sums levied were distributed among members who were doing more acquiring than issuing, and they could freely use the sums thus levied. There was no need to offset costs. It was simply a cash transfer to discourage issuing activity and encourage acquiring activity. The issuers obviously had no ability to negotiate the fee down, and it was distributed by the scheme multilaterally.
So this was about, so the impact on competition was on the issuing market?
Yes, my lord, exactly. If you go over the page to 1166, you see what the Commission, the European Commission, was worried about. Paragraph 8, the Commission said the relevant market, first indent, is for the market for the issue of payment cards in France, because this fee was discouraging issuance. It was actually restricting competition in the issuing market. And the Commission said that has an anti-competitive object, which is obvious from the way the measures have been designed. And that is expressed in more detail in the rest of paragraph 8. So we skip ahead, please, to page 1174, and we have the legal test, which again, in view of the time, I'll just take as read. Over the page 1175, the court sets out how to identify whether conduct is of its nature so inherently harmful as to be a by-object infringement. Very bottom of paragraph 51, the court says experience shows that such behaviour leads to falls in production and price increases, resulting in poor allocation of resources to the detriment of consumers, and I'll come back to that. 53, in order to show a sufficient degree of harm to be a by-object infringement, you must look at the content of the provisions, objectives and economic and legal context, as well as the real conditions of the functioning and structure of the market. And the General Court agreed with the European Commission, upheld the by-object infringement finding. If you go to page 1177, we see how the General Court found it was a by-object infringement. Paragraph 63, just like the tribunal, the General Court held the requirements of balance between the issuing and acquisition activities within the card scheme system did not have to be examined in the context of what was then Article 81.1 is now 1011, since the only market taken into account was the downstream market for the issue of payment cards. General Court said we must only look at the market where the harm is said to arise. We don't, under 1011, look at balance and effects in the other side of the market. And then we go to please 1178, Judgment of the Court of Justice, paragraph 72. The Court of Justice says it's clear from the General Court's judgment they rejected the appellant's claim that it was apparent from the formulas prescribed for the measures at issue that the latter sought to develop the acquisition activities of the members in order to achieve an optimal rate of balance between issuing and acquisition activities. It's not disputed these formulas encourage the members of the grouping, in order to avoid the payment of fees, not to exceed a certain volume of card issuing that enable them to achieve a given ratio. 73, General Court found in a card payment system that it's by nature two-sided. The issuing and acquisition activities are essential to one another and to the operation of that system. First, traders would not agree to join the scheme if the number of card holders was insufficient. And secondly, consumers would not wish to hold a card if it could not be used with a sufficient number of traders. Having therefore found that there were interactions between the issuing and acquisition activities of the payment system, and that those activities produced indirect network effects, which is exactly what we've just looked at as a matter of economics, and since the extent of the merchant's acceptance of cards and the number of cards in circulation affects each other, the General Court could not, without erring in law, conclude that the measures at issue had as their object the restriction of competition in the meaning of what is now Article 101.1. That is directly contrary to the finding of the tribunal. And having acknowledged the formulas for these measures sought to establish a certain ratio, not whether they did or whether certain precise costs were being offset, just they sought to establish a certain ratio between issuing and acquisition activities, the General Court is entitled at most to infer from this that those measures had as their object the imposition of a financial contribution on the members of the grouping, which benefit from the efforts of other members. Such an object cannot be regarded as being, by its very nature, harmful to the proper functioning of normal competition. So I see the clock, my lords, and I'll pause there. I have a little bit more to do, and I will seek over the short adjournment to cut down my submissions. I think you have my central point on this, and so I'll seek to be as brief as possible, but I will need a little more of your time, which will come out of my reply.
How much more time do you need?
I am halfway through my object, so another 10 minutes, if you'll permit me. And I won't, if it reassures the court, I won't develop my other arguments orally. I will leave that to the skeleton arguments.
Yeah, well, I think we'll start at 10 to 2 then.
I'm obliged to.
Which gives the respondent time to respond properly. So 10 to 2.